Welcome to LexTalks Legal Topics Simplified. We're diving deep today into writ jurisdiction in India.
It's a cornerstone, of Indian law.
As you're learning in law school.
But as you know, it can be pretty complex.
Oh, absolutely.
We're here to help you really kind of grasp
Make sense of it all.
what it's all about. Yeah.
Break it down. And we're actually going to be covering a lot today. So we'll be covering the meaning of writs, different kinds of writs, the jurisdiction of the Supreme Court and the high courts when it comes to writs, which authorities are subject to writ jurisdiction. And then finally, we'll wrap up by exploring the concept of locus standing in writ jurisdiction.
That's right. We're going beyond those dry textbook definitions.
Yes.
Really give you a solid
Practical understanding
of how writs actually work.
in the real world.
In the real world.
Yeah. Okay, so to kick things off, let's just, I guess, take a step back and talk about what a writ actually is. I mean, you hear this term all the time, but what does it actually mean in a practical sense?
You can think of a writ as a direct order, a legal command, from a higher court to a lower court or to a government official. It's essentially the higher court saying, hey, you need to do this.
Right.
Or stop doing that.
So it's about ensuring that the law is being followed and that rights are being protected.
Exactly. And that's why writs are so powerful. It's a direct intervention from, the highest levels of the judicial system.
Right.
Meant to provide immediate relief when things go wrong, especially when fundamental rights are being violated.
Now, I know there are different types of writs, each with its own purpose. So let's break those down, starting with habeas corpus.
Yeah.
That one always sounds so serious, like something out of like a historical drama.
It does. It does have a certain weight to it.
Yeah.
Habeas corpus literally means you shall have the body.
Okay.
And it's used to challenge unlawful detention.
Okay.
So if someone's being held illegally, a writ of habeas corpus is their legal recourse to secure their release.
I see. So it's about protecting personal liberty and ensuring that no one is imprisoned without a just cause.
Precisely.
Yeah.
And it goes beyond just outright illegal detention. Habeas corpus can also address things like maltreatment of prisoners,
Okay.
making sure their basic rights are being respected even while they're incarcerated.
Now on to Mandamus.
We command.
Yes. That one definitely sounds like the court is putting its foot down.
It is.
Yeah.
With a writ of mandamus, the court is commanding a public official to perform a mandatory duty.
Okay.
Let's say an official is neglecting a duty they're legally obligated to do.
Right.
Mandamus is a way to compel them to act.
So it's like a legal nudge, a way of saying, hey, you need to get this done. It's your job.
Yeah.
Yeah.
And it can even be used when an official has discretion in how they act, but they're refusing to act at all. The court can force them to exercise their discretion, but it can't dictate the specific outcome.
Interesting. So it's about ensuring that officials fulfill their responsibilities, but it also respects their authority to make decisions within their roles.
That's a good way to put it, yeah.
Okay. Next up, certiorari.
To be certified.
To be certified.
Okay.
This writ is all about judicial review.
Okay.
It allows a higher court to quash an order that's passed by a lower court or tribunal if it exceeded its jurisdiction, violated principles of natural justice, or made some other serious error.
So it's a way for higher courts to correct errors made by lower courts and ensure that legal proceedings are fair and just.
Absolutely. Think of it as a check and balance within the judicial system itself.
Okay. On to prohibition.
Ooh.
That sounds like a pretty strong word in a legal context.
It does have a certain finality to it.
Yeah.
A writ of prohibition is similar to certiorari.
In that it prevents a lower court or tribunal from exceeding its jurisdiction or violating natural justice.
Right.
The key difference is timing.
Timing. How so?
So certiorari comes into play after an incorrect order has been issued.
Right.
Prohibition, on the other hand, acts before the order is made.
Oh, okay.
It's a way to prevent an illegal action from happening in the first place.
Oh, so it's a preemptive strike.
Exactly.
Stopping a court from acting beyond its powers. I'm seeing a theme here. These writs are all about checks and balances, right?
Yeah.
Like making sure that power is used appropriately within the legal system.
You're absolutely right. They ensure accountability at all levels.
Okay, and last but not least, we have quo warranto.
By what warrant?
Okay, now we're really getting into the nitty-gritty of challenging authority.
This one is all about questioning the legitimacy of someone holding a public office.
Okay.
It's used to challenge someone who might be occupying a position without having the proper authority to do so.
So it's about making sure that people in positions of power actually have the right to be there.
Exactly.
Yeah.
It's a way to ensure transparency and accountability in how public offices are filled and held.
This is fascinating stuff. It's really starting to make sense how these different writs kind of work together to protect rights and keep the legal system functioning properly.
It's like a toolkit.
Yeah.
With each writ serving a very distinct purpose. Now, to really understand how writs work, we need to delve into the specifics, jurisdictions of the Supreme Court and the high courts. After all, they're the ones wielding this powerful tool.
Right. And while we're at it, I think we also need to understand which authorities are actually subject to writ jurisdiction.
Yeah.
It's not always as straightforward as it seems, but first, let's just take a moment to clarify a key concept, locus standi.
Ah, yes, standing.
Yes.
This is crucial.
This is important.
Locus standi is the legal right to bring a case before the court. In the world of writs, it means that the person filing a writ petition must be directly affected by the issue at hand.
Okay, so if I see something unjust happening, but it doesn't directly impact me, I can't just file a writ petition.
That's the general rule. However, there are exceptions, like in the case of public interest litigation or PIL. This allows concerned citizens to file writs on behalf of the public good, even if their personal rights aren't directly violated.
Okay, so there are ways for people to step up and fight for justice, even in situations where they might not be personally affected.
Exactly.
It's good to know.
It's an important distinction.
Yeah. I think we've laid some good groundwork here, defining what writs are, outlining the different types. But now we need to dive deeper into these nuances of jurisdiction and who exactly can be subject to these writs.
Absolutely.
Yeah.
We'll unpack all that and more.
After a quick break.
Stay with us.
Stay tuned.
Yeah.
Yeah. All right, so we've covered like the basics of what writs are and the different types. Now let's get into the specifics of like who can issue these writs and under what circumstances.
Okay.
I know both the Supreme Court and high courts have the power to issue writs.
Right.
But like, what are the key differences in their jurisdiction?
You've hit on a crucial point.
Yeah.
While both courts have this power,
Right.
their jurisdiction is defined a bit differently within the Indian Constitution.
Okay.
The Supreme Court's power to issue writs stems from Article 32.
Okay.
This article specifically empowers the Supreme Court to issue writs for the enforcement of fundamental rights.
So if someone's fundamental right has been violated, they can directly petition the Supreme Court for relief through a writ.
That's right.
Okay.
Think of the Supreme Court as like the ultimate guardian of fundamental rights.
Right.
Stepping in when those rights are threatened.
Powerful.
Now, the high courts actually have a broader scope when it comes to writs.
Okay.
Article 226 of the Constitution empowers them to issue writs not just for the enforcement of fundamental rights, but also for any other purpose.
For any other purpose. That sounds incredibly broad.
Yeah.
What does that mean in practical terms?
It means that high courts can issue writs in a wider range of situations.
Okay.
Even when fundamental rights aren't directly at stake.
Okay.
They can address legal wrongs and ensure justice in a broader array of cases.
So hypothetically, if someone has a grievance that falls outside the scope of fundamental rights,
Right.
they might still be able to seek redress through a writ petition in a high court.
Potentially, yes.
Okay.
Of course, there are other legal principles and precedents that come into play. It's not a guaranteed path to relief.
Right.
The existence of alternative legal remedies, for instance, could be a factor in the court's decision. But this broader jurisdiction certainly gives the high courts more flexibility in addressing injustice.
This makes me think about something we touched upon earlier.
Yeah.
The authority is subject to writ jurisdiction.
Right.
We tend to associate writs with actions taken by government officials or bodies.
Yes.
But is that always the case?
It's a common misconception that writs only apply to government entities.
Okay.
While that's the traditional understanding,
Uh-huh.
there have been some interesting developments in recent years.
Okay.
The Supreme Court has, in certain cases, expanded the reach of writ jurisdiction to include some private bodies.
Oh, wow.
Particularly those performing public functions.
You've piqued my interest.
Yeah.
Can you give us an example of how this might work in practice?
Sure. Let's consider a situation where a private educational institution is receiving government funding.
Okay.
Or has been granted a special status that allows it to function almost like a public institution.
Right.
In such a scenario, the court might determine that this private entity is essentially performing a public function.
And therefore would be subject to the same level of scrutiny and accountability as a government entity.
Exactly.
Wow.
This is a significant development, blurring the lines between public and private entities in the eyes of writ jurisdiction.
Yeah.
It shows that the legal system is adapting to the changing dynamics of society.
This brings us to another key concept.
Right.
Locus standi.
Yeah.
Can you remind our listener what that means in the context of writ jurisdiction?
Locus standi refers to the legal right to bring a case before the court.
Okay.
In the realm of writs, it means that the person filing a writ petition must demonstrate that they are directly affected by the issue at hand.
So you can't just file a writ petition because you're generally concerned about an issue.
Right.
You need to show how it personally impacts you.
That's the general rule.
Right.
But as we discussed earlier, public interest litigation, or PIL, provides an important exception.
Yes.
PIL allows individuals or groups to file writ petitions on behalf of a larger public interest, even if they aren't personally harmed.
Right.
It's a way for concerned citizens to act as watchdogs and hold those in power accountable.
That's a crucial distinction.
It is.
It means that even if you're not directly victimized by an unjust action, you still have a legal avenue to seek redress.
Precisely.
Yeah.
It's a testament to the power of collective action.
And the importance of citizen participation in upholding the rule of law.
This has been a really illuminating discussion.
It has.
I feel like we've gone beyond the textbook definitions and really started to grasp the complexities of writ jurisdiction.
Absolutely.
Before we wrap things up, is there anything else you'd like to highlight for our listener?
Sure.
About the power and importance of writs?
One final thought I'd offer is that while writs are powerful tools for seeking justice, it's crucial to remember that the court's power to issue them is discretionary.
Okay.
They carefully weigh the facts of each case, consider the availability of alternative remedies, and ultimately decide whether issuing a writ is the most appropriate course of action.
So just because someone files a writ petition, it doesn't automatically guarantee a favorable outcome.
That's right.
Okay.
The courts have a responsibility to exercise their discretion judiciously.
Yeah.
Considering all the factors involved and upholding the principles of fairness and justice. Well said. I think our listener, with their sharp legal mind, is probably soaking all this in and starting to see the bigger picture. Writs are more than just legal mechanisms.
Yeah.
They're essential safeguards against injustice.
Absolutely. And understanding how they work is key to navigating the legal system and advocating for a more just and equitable society.
On that note, let's bring this deep dive to a close. We've been on quite a journey today. I mean, really breaking down writ jurisdiction, the types of writs, powers of the Supreme Court and the high courts, who can file, even those cases we talked about where private bodies, those were interesting cases, were held accountable under writ jurisdiction.
It's been fascinating, hasn't it? Exploring not just the mechanics of the writs, but their impact on ensuring justice, upholding the rule of law, in India especially.
It strikes me that writ jurisdiction, it's more than just a legal concept. You know what I mean? It's almost a reflection of the judiciary's commitment to protect
fairness,
individual rights and ensuring fairness. It's like having this powerful tool in the legal system that can be used to right wrongs and hold those in power accountable.
It's a safeguard, It's a mechanism that ensures that even when other avenues fail, there's a way to seek justice and ensure that the law is applied fairly and impartially.
Yeah, and it's not just about individual cases either.
No.
Right. The ripple effects of writ jurisdiction can be felt across society as a whole.
Yeah.
I mean, think about those landmark judgments we've seen where writs have been used to address systemic issues, protect the environment, even shape government policies. It's amazing.
Absolutely. Writs have played a really pivotal role in shaping the legal landscape of India.
Yeah.
They've been instrumental in protecting fundamental rights, promoting social justice, upholding the principles of a democratic society.
Our listener out there, being a law student, I think they're probably starting to see just how crucial a deep understanding of this is. Of writ jurisdiction is for anyone pursuing a career in law. I mean, it's not just about passing an exam. It's about being equipped to make a real difference in the world.
A solid grasp of writ jurisdiction is absolutely essential for any aspiring lawyer. I mean, it's a cornerstone of legal practice. It allows you to, advocate for your clients effectively, navigate those complexities of the judicial system.
So to our listener out there, delve into this topic. Don't just memorize those definitions.
Yeah.
Explore the landmark cases, understand the arguments, see how these writs have been used to really shape the fabric of Indian law.
And remember, the law is not static. It's constantly evolving. Writ jurisdiction continues to adapt to new challenges, societal changes. So stay curious, stay informed, and keep that legal mind of yours engaged.
Great advice. It's been such a pleasure having you on LexTalks.
The pleasure's all mine.
Thank you for sharing your expertise with us. And to our listener, thank you for being a part of LexTalks. Subscribe and stay informed.